Good morning, everyone, and welcome to today's webinar panel on India's suspension of the Indus Waters Treaty, underlying causes and consequences for Pakistan. My name is Paul Kybel, and I'm here in my capacity as projects chair for the Executive Council of the International Association for Water Law, IDA. I say good morning to you because for me, I'm here in Berkeley, California. It is 6 o'clock a.m. I know we have, I think, about 180 people or so registered from all over the world, so I know it's not the morning for many of you. Before we get started with the substance of the presentations, I wanted to go over certain logistical and formatting issues and do some introductions. I did want to welcome you on behalf of ADA, the International Association for Water Law, which is an organization existed since the 1960s, that although it's not exclusively to lawyers, it's focused on both issues related to transboundary water law, as well as sort of best practices of domestic law. Today, we're obviously going to be focusing on transboundary laws. I did want to provide an opportunity. We have a co-sponsor for today's event, which is the Geneva Water Hub. And Mara Tagnino, one of our presenters, is from the Geneva Water Hub. Mara, I just wanted to give you an opportunity to welcome people as well.
Thank you, Paul. So on behalf of the Geneva Water Hub and its platform for international water law hosted at the Faculty of Law of the University of Geneva, I welcome warmly the participants. It is a real pleasure to host this webinar with AIDA, and I think we share with AIDA the passion to better understand the implication of the principles of international water law for countries sharing groundwater and surface water resources. And also, I'm honored to be a member of the International Steering Committee of the first Global Water Law Congress, which will be held next year and covers the relationship, among other topics, of international water law with climate change law and biodiversity law. So, again, a warm welcome on behalf of the Geneva Water Hub.
Thank you. Okay, so some logistical matters and some formatting matters, just so we know. The first that I wanted item that I wanted to cover is translation. We have people from around the world. The panel itself is going to be in English, but we have a translation function. So if you go to the bottom of your screen where it says show captions, you're going to see a translation button. And the translation button enables you to choose a language setting. We can just read it, but at the bottom of your screen, that there will be translations on your screen into the language that you've selected. It's slightly delayed, but very, very little. So if you're more comfortable following along with that, as opposed to listening in English, I wanted you to be aware of that function. And once again, if you go down, find show captions, look for the translation button, and then there's a series of directions how to enable, I'm just looking at it right now, how to enable caption translation in Zoom. Second item that I wanted to cover is we're going to have, when I go over the format, we're going to have an opportunity for questions and cross dialogue after the presentations, and we want to have an opportunity for people that are attendees to submit questions or discussion topics for the panel during the program. If you go to the Q&A box, the question and answer box, that's where we're going to ask that you place your questions or discussion topics if they're directed towards a particular panelist. You can do so, and we will be monitoring that during the program. So when we get to that portion of it, we can then turn to those questions. Okay, I'm now going to introduce the panelists and talk about the format a little bit. I apologize for this cough. Interestingly, our panelists, I believe, are actually all members of IDA as well. That wasn't necessarily planned, but that's the way it happened. I'm Paul Kybel. I'll be serving as moderator. other three panelists, Dr. Salman, M.A. Salman, former lead counsel and water law advisor at the World Bank, and also distinguished honorary fellow at the International Water Resources Association. Welcome, Salman. Dr. Mara Tagnino, who's a senior lecturer at the University of Geneva and a lead legal specialist there with their platform on international water law, which is often otherwise known as the Geneva Water Hub. And finally, Dr. Kishore Upreti, who's a former legal advisor with the Asian Infrastructure Investment Bank and also a former senior lawyer with the World Bank. So we've got a panel with a lot of expertise, not only in the Indus Waters Treaty specifically, but in international water law more generally, because we are going to be talking about the relationship between those two today, about how international water law principles actually are related to the current controversy that's going on regarding the status of the Indus Waters Treaty. And once again, just to echo Mara, we are very excited. We're in the planning stages right now, but in June 2026, we will be holding the first IDA World Water Law Congress. It's going to be in Oslo, Norway. We're doing it with colleagues at the University of Oslo, and we expect it to be a great event. In years past, as some of you know, IDA has sort of worked with the World Water Congress and sort of, I'm going to say tagged along, but sort of been adjacent to that. Thank you, Gabriel. And this is the first time. So we hope to see as many of you as we can in Norway. Sorry about this cough. Okay. So in terms of the format, I'll make some brief introductory remarks and then turn things over first to Salman, then to Kishore, then to Mara. They will do presentations of around 20 minutes, maybe a little bit less if we can constrain them in their remarks. And at that point, we should, if we can be disciplined about the time, open it up and have about 20 minutes or so of what I would call, questions, cross-dialogue, discussion. I have some questions that I put to them in advance that hopefully we'll get to, but I think we're going to start initially by turning to the questions and discussion topics that are proposed by the other registrants in the box. Okay, so that's the general format that we're using. So, like I said, I'm going to make some brief introductory remarks, and it's more about framing. So, the Indus Waters Treaty negotiated with the assistance and involvement of the World Bank in 1960 between India and Pakistan. Salman will discuss a little bit of the structure of it and the key components of it. But I think what I wanted to emphasize in the opening remarks is that, it's now been, let's say we're 65 years in, and amongst the transboundary river regimes that are out there, the India Waters Treaty has proven one of the most durable and effective, and often under very difficult circumstances. There's certainly been no shortage of political and military and national security issues going on between India and Pakistan during that period. But the treaty itself has held together well and proved functional, especially some of the dispute resolution mechanisms that have been relied upon, which often involve the World Bank. I'm sure that Salman and Kishore will discuss that a little bit more. So the recent developments that have happened, which are very, very challenging, are taking place in the context of a regime that has been rather stable, and the fact that it's in a period of instability right now. I'm not going to get into the substance of that. I'll leave our presenters to. Is noteworthy. Is noteworthy also, I think, globally, because other regimes have often looked to the Indus Waters Treaties as a model of stability, and that's being called into question. The second point that I wanted to touch on relates more to international water law in general. And at this point in time, a key fundamental principle within international water law is what is often referred to as equitable and reasonable utilization. And obviously, each of those terms are loaded, and we can spend a lot of time talking about them. But I really wanted to focus on the aspects of equitable utilization. So, equitable utilization is a principle that is reflected in most of the major international water law treaties, including the United Nations Transboundary Watercourse Convention. And I think what is important for purposes of our webinar today is that, as understood in international water law, the term equitable utilization of water resources in transboundary watersheds does not mean equal. So let's suppose you have, as we do with the Indus waters basin, you have two countries that are riparian countries on the transboundary watercourse. The principle of equitable utilization doesn't say country A gets 50% and country B gets 50%. The way it's articulated in international water law, both in court decisions and also in the treaties themselves, is really that the term equitable is a placeholder for fairness. We can break down all those elements of fairness, reliance, need, population, vital human needs. But at the end of the day, it really comes down to a series of criteria and factors that reflect, is it fair? So we have a situation with the Indus Waters Treaty where, at least in 1960, when it was negotiated, um, the parties were able to come to an agreement. They executed it because there was a sense that the terms of it, overall, taken as a whole, were fair, were equitable. Does that mean that India got 50% of all the waters in the basin and Pakistan got 50%? No, it doesn't mean that. But it means that there was some agreement, at least at that point in time in history, 65 years ago, that the terms in the allocation were reasonably fair, reasonably equitable. We find ourselves today, 65 years later, revisiting that. And I think this is particularly true, not to jump ahead to the substance, from India's point of view. That India looks now on the terms that were negotiated and the structure of the treaty and the way those water resources were allocated, and has a changed opinion of whether it's equitable, as to whether it's fair. And this relates both to the amount of water that is allocated to the two respective countries, to India and Pakistan. And we'll get into this somewhat. It also relates to other national security issues, maybe terrorism issues, and some of the issues that are going on in Kashmir as of late. And finds that those activities, which are really maybe more of a national security concern, and Pakistan's response to it has implications for the treaty. And it's this combination of fairness concerns and national security concerns that seem to be at the root of the more recent decisions by India to, we're going to use these two terms, suspension and abeyance. We're going to have to unpack them because they're not really terms that are used in the treaty themselves. They're terms that India has used, but they're not found in the treaty itself. But that'll be something for us to discuss. So I just wanted to put particularly that second point out there for you to consider now, which is that as we're discussing the treaty itself, the status of the treaty, what suspension means, the implications of it, all of this is taking place against the backdrop of broader international legal principles within the international water law field. And in particular, for me, I think focusing in on this principle of equitable utilization is really key. And particularly there's a temporal component to it. The temporal component meaning under international law, if you have a provision or an allocation in a treaty that is viewed as satisfying equitable utilization at one point in time, for our purposes, let's say 1960, but that determination, at least by one of the parties, is revisited later, where does that leave you? What are the circumstances when it's reasonable, appropriate, valid, justifiable to not to request renegotiation of the treaties, but something stronger than that, which I think is what India's position right now, which is really to insist on it as a condition of remaining in the treaty. And is that a viable, is that a credible position under international law? So I will submit that to you as a broad picture item. Maybe we'll return to that later in the cross dialogue, but for now, I think that's enough to set it up. So I'm going to turn things over now to Salman, and I look forward to your remarks. And once again, we are going to be as vigorous as we can in keeping you within your time slot so that the other speakers have time and that we have time for discussion at the end. So thank you very much, and I'll turn it over.
Thank you very much, Paul. I'll be talking about the Indus Waters Treaty and from historical and legal overview. My presentation will focus on the Indus River Basin, the Indus irrigation scheme. I will move to the partitioning and the emergence of the two countries in dispute and the temporary arrangements that didn't last. Get to the point where the World Bank got involved and how its mediation efforts went ahead and with the joint ownership and then the quantitative division of water and then the division of rivers that finally got in the treaty. I'll highlight some issues with the division by rivers, and then I'll talk about the main features of the Indus Waters Treaty and end up with some concluding remarks. I have 20 minutes, Paul, right?
Yes, if you could trim that to
I'll
like
try,
18, that'd be wonderful.
The Indus River, the main river is about 1,980 kilometers. It starts originates in China, in the Tibetan Plateau of China, crosses India from the north, as you could see, and then flows into Pakistan. It is joined from the west by the Kabul River coming from Afghanistan, and also by the Konar River, which originates in both Afghanistan and Pakistan. And then from the west, it's joined by the other 5 rivers of the Indus Basin River, the Jhelum, the Chenab, the Ravi, the Sutlej, and the Peas. The 5 rivers form the Indus River Basin, flow down for about 200 kilometers before they empty whatever water that is left in the Arabian Sea. The aggregate annual flow is about 168 billion cubic meters. It's twice the Nile, 10 times the Colorado River. The drainage area is about 450 square miles. 47% of that is in Pakistan, 39% in India, and 14% on the catchment area is in China and Afghanistan, 8 and 6 respectively. China contributes about 10 to 15% of the Indus River. We could see that as I mentioned earlier, the Indus originates there. The Sutlej also originates in China. Afghanistan contributes about 12% of the Indus through the Kabul and the Konar. So both China and Afghanistan are riparians, but they are not parties to the Indus Waters Treaty, and this is important to keep in mind. The Indus Basin Irrigation Scheme is one of the oldest. The irrigation was practiced there in prehistoric times, but the modern development started in 1840. There were 26 million acres in 1947 and 34,000 miles of main canals. 50 million people relied it in 1947 when the partition took place. Currently over 300 million people, which shows the challenges. It's the largest contiguous irrigation scheme in the world and considered science of canal engineering. The partitioning of the subcontinent in 1947 triggered the Indus water dispute. In Punjab, the heart of the Indus Basin, irrigation scheme was divided between the two countries. The boundary cut across the Indus Basin. The most water-rich headwater remained in India, and Pakistan emerged as the lower water poor riparian. We have to remember that Indus Basin irrigates about 80% of Pakistan arid land. Hence, the dispute in the Indus erupted. I think Paul spoke about the equitable and reasonable utilization, but let's look at the basis for the parties' claims when the partition took place. Pakistan claimed historic rights. Those are my rights since the beginning of history. But basically, this is what the lower riparians claim, the historic rights. India claimed the rights over rivers flowing within its territory. That's basically sovereignty. And then the parties entered into a series of temporary short-term agreements, but that approach did not last and did not work. And the dispute persisted and continued, leading to the World Bank intervention. How did the World Bank got to intervene? It was through an article written by David Lilienthal, the former chairman of the Tennessee Valley Authority, published in August 1951 on the Indus dispute in the Collier magazine, titled "Another Korea in the Making?" question mark, urging the World Bank to intervene, saying that you have the expertise, you have the know-how, you have the money, suggesting joint management of the Indus Basin scheme based on those three factors: knowledge, know-how, and knowledge and expertise, uh, and the suggestion was to joint management, but the bank agreed to intervene after a series of meetings and negotiation. And in 1951, in September, Eugene Black, the president of the World Bank, offered the bank good offices to the two leaders. I want you to remember those were good offices because the process went beyond that later on. The bank offer of good offices was accepted in September 1951, and negotiations started in May 1952. And the bank adopted leading start proposal of jointly developed and operated scheme. Parties agreed to study the proposal. However, after a few months, the bank proposal was turned down by both parties. Neither of them was enthusiastic to it. The concerns was over sovereignty, then other issues of joint management, who gets say what. So the bank realized that the proposal is going nowhere and abandoned it and asked the parties for their own proposal. And then the first plan by each party came. The first plan from India spoke about 119 million acre feet total, of which 90 million acre feet will go to Pakistan and 29 to India. So basically 75% to Pakistan, 25%. That was in the way Pakistan saw it. Pakistan saw it as 118, and it wanted 102 million acre feet and 15.5 to India. That's 86 and 14 as opposed to 75 and 25. So clearly the gap was large, and there was wide difference between the allocation for each party. The disagreement persisted, pushing the need for another plan, this time based on rivers rather than quantitative division of water. The bank mediation team was headed by William Elif, who was assistant to the president, which shows the importance that the bank assigned to its good offices or mediation process. So the second plan, India proposed that it would get all the waters of the eastern rivers. The eastern rivers are these three eastern rivers of the Indus Basin, the Ravi, Bees, and Sutlej. And Pakistan would got and then the western rivers are the Indus, Chelom, and Chenab. So India's plan was that they would get all the waters of the eastern rivers and 7% of the western rivers. That wasn't the way Pakistan saw it. Pakistan saw it that they would get all the waters of the western rivers and 70% of the waters of the eastern rivers. So the gap was even getting wider. This is just a quick look at the western rivers and the eastern rivers, the Sutlej, the Ravi, and Bees, the eastern rivers, and the Indus, Chelom, and Chenab are the western rivers. So the gap was wide, and the bank, realizing the deadlock, intervened with its own proposal. The proposal of the bank was just eastern rivers to India and western rivers to Pakistan. India accepted that proposal. Pakistan rejected it, claiming that not enough water in western rivers to compensate for its losses from the eastern rivers. And so this is the India, the eastern rivers, Sutlej, Bees, and Ravi, and this is what Pakistan would get under the bank proposal, the Indus, Jhelum, and Chenab. The bank agreed to look into Pakistan's reasons for rejecting the proposal, and after close to a year of study, found merits in the reason for rejection, that there isn't really enough water in the western rivers to compensate for the losses of the water of the eastern river. Issued an aide memoir adjusting the proposal. They recognized the need for additional storage reservoir to provide Pakistan with additional water. However, the storage reservoir would need money. So the problem was where to fund it. The bank was able to raise 800 million largely grant funding, including 62 million from India. That resolved the final hurdle, and then following that, there was an agreement on the remaining points, on the details of the agreement, and the treaty was signed in Karachi, Pakistan, on September 1996. That's 9 years after the start of the negotiation, until the bank proposed its good offices. In terms of translation of the rivers into figures, the Indus is 90 million cubic meters, the Jhelum is 23, the Chenab is 23. That gives Pakistan 136 billion cubic meters. On the eastern rivers, the Sutlej is 13.5, Beas is 12.5, 2.7, and Ravi is 6.4. That's a total of 32.6 for eastern rivers for India. And so, translating that into percentage, Pakistan would get 80% of the waters of the Indus River, and India would get 20%. And this is somehow close to what the initial proposal that the two parties put together, where India proposed 75% for Pakistan, 25 for India, and Pakistan proposed 86 for Pakistan and 14 for India. So it's just really in the middle of it. The treaty was signed by Jawaharlal Nehru, the then Prime Minister of India, President Ayub of Pakistan, and then Vice President El for the World Bank. This is the photo of the signature. And this is the signature page of the treaty. We see the signature of Jawaharlal Nehru and the Ayub, then Mr. Elf. About the Indus Water Treaty, one of the most comprehensive international water treaties. I've spent a lot of time studying it with my friend Kishore, with Undala Alam, with some other people. It's really one of the most comprehensive, 150 pages, 12 articles, 8 annexures. A number of annexures have appendices. Some have more than one appendix, and some appendices have forms. So it's really very detailed. And there are a number of unique features. I'll mention just 4 of them. It's concluded after 9 years of continuous negotiation in Asia, Europe, and America. It's based on the allocation of rivers, not volumes of water. Perhaps the first treaty to do this, allocate on the basis of rivers, not quantity water. It's the only international water treaty signed by a third party, the World Bank. It entered into force upon exchange of ratification instruments on January 12, 1961. It was signed in September 19, 1960. But interestingly enough, it took effect retroactively in April 1, 1960, for reasons regarding the transitional arrangement and some of the earlier agreements and some of the work that started there. The main features or the main methods addressed by the treaty, as we mentioned, the eastern rivers to India, western rivers to Pakistan. There are financial provisions. It's the establishment of the Indus Basin Development Fund, which was administered by the bank, the 800 million, basically to put in place the replacement works. Lengthy article about the exchange of data and information, and also on notification, perhaps one of the earliest treaties to deal with notification, and that was referred to in a number of other treaties and some of the decisions of the regional international courts and regional courts. It established the Permanent Indus Commission for interpretation and implementation of the treaty, a virtual but very effective commission. Then it has a settlement, the differences and disputes, which we'll come to it later on. And there are 3 articles on the emergency provisions about the transition period, and general provisions about the applicability of the treaty, and then the final provisions about the entry into force, which I just mentioned. There are 8 annexures, which are very long, about 130 pages. Annexure A on exchange of notes between the 2 governments. Annexure B is on agricultural use of Ravi River. It's one of the eastern river by Pakistan. And the reason this is it has a special and a separate annex is because the Ravi River forms, for its considerable stretches, the boundaries between India and Pakistan, zigzagging back and forth, and that created some issues for the 2 parties. Then there are 3 annexures for the uses of the western rivers by India for agriculture, for hydropower, for storage, and this is basically the causes of the disputes that are now before the neutral expert and the court of arbitration. And then there are 3 annexes: the Annexure F on the neutral expert, Annexure G on the court of arbitration, and Annexure H on the transitional arrangements, which would lead to the severance of the western rivers and eastern rivers. Lengthy annexures, as I said, 130 pages, and emphasis and the details really are on the uses of western rivers by India. This is really the crux of the treaty, and it's really the crux of the disputes that are now there. Again, just a quick reminder of the western and eastern rivers, and the differences and disputes are classified into 3. The question, this is what the treaty says. The questions, disagreements are classified into questions, differences, and disputes. Questions would be handled by the Permanent Indus Commission. The differences would have to go to the neutral expert. And Annexure F lists 23 matters as questions to be referred to the neutral expert, primarily technical engineering matters. This is very important because the neutral expert has to be a highly qualified engineer. And the Annexure F speaks about the appointment process, the funding, and the finality of decision. And then disputes are to be resolved by the Court of Arbitration. That's the Annexure G. And this is primarily legal matters. So it's very interesting that the treaty put this line of demarcation between technical engineering matters and legal matters. Technical matters, engineering would go to the neutral expert, and legal matters would go to the Court of Arbitration. So it's a very, very unique and complex process with a major role for the World Bank, which we'll come to it in a minute. The bank signed the treaty for a number of purposes. Article 5, the financial provisions of the Indus Basin Development Fund, which it administers. Annexure Article 10, the emergency provisions, which is the transitional period, and then Annexure F, the neutral expert, basically administering the neutral expert process. Annexure G, the Court of Arbitration, selection of the chairman. Annexure H, the transitional arrangement. Interesting enough, the Court of Arbitration, the current one that's looking into the Western Rivers cases, called the World Bank role special but essentially ministerial role under the treaty. The two terms, the two words, ministerial role under the treaty, which is very interesting. And this is a signature page, and we will see at the end the signature of Mr. Elif. It says, for the purposes specified in Articles 5, 10, Annexure F, G, and H. And this is a very unique thing. You have three signatories, two for the full treaty, and the third signatory for purposes specified under the signature page. The bank they succeeded, and there were a number of it was really a remarkable success. Not that because I worked in the World Bank or worked in this treaty, but absolutely there is no doubt that it was a marvelous success. And the many reasons contributed to that. Basically, the first one, the involvement at the highest level and the continuity of the main actors. You see, this started with Jean Black, the president of the World Bank, who happened to be there during the period the treaty was being negotiated. He visited India and Pakistan 3 times, 1952, 1958, 1959, which really gave a major push to the process. William Elf, assistant president and then vice president, was there full time working with the parties. Sometimes when the negotiations get deadlocked, he would just pull the leaders of the leaders of delegations and sit with them for hours, sometimes for days, so that he could resolve those issues before, rather than have them dealt with in the plenary. And the bank used this leverage and the convening power, was able to obtain concessions from the two parties on difficult issues. And then there is a longevity of the process, 9 years. It was difficult for either party to pull after 9 years of negotiation. That helped for the bank to succeed. And then the bank was able to de-link the dispute from other issues, particularly the Kashmir. And then the bank agreed to play a major role in implementation, the Indus Basin Development Fund, and in the dispute settlement. Also, and this is one important part, it was the ability of the bank to raise the necessary funds, 800 million, so it could de-link the Western rivers from Eastern rivers and provide more water to Pakistan. The Indus Basin Development Fund consists of 800 million, 54 million grants from Australia, Canada, Germany, New Zealand, United Kingdom, and USA. 174 million, about 62 million sterling pounds from India, contribution by India as a grant, 90 million loan, bank loan, and it helped finance 2 dams, the Mangala and Tarbella, 8 link canals and tube wells. This is the Mangala on the Jhelum River, which was financed by the Indus Basin Development Fund, and this is the Tarbella. Both were really major reasons for the success of the negotiation process and the treaty. As I mentioned earlier, the bank role started as good offices. Later on, it was referred to as mediation. But some experts think that it is more than mediation. It's really conciliation because it's brought its own ideas and its own plans. And this leads me to the final slide, the concluding remarks. The Indus Water Treaty is a lengthy, complex, but a very fair agreement. It consists of articles, annexes, forms, resilient, durable, I think the Paul used the word durable, I use the word resilient, survived three wars, 1965 war, 1971, and 1999. However, there is a growing resentment by India over the restriction of its uses of the Western rivers. And this is what I said, most of the time, especially in the middle of the negotiation, the time was spent on these issues. How can India use the Western rivers without affecting Pakistan's right on those rivers? And this is still a problem, and this is what we have now. As I mentioned, the resentment on the restrictions led to the suspension, which we have, which was announced in April. Suspension abeyance April 2025. As I mentioned, repeatedly, its own international water treaty to be signed by the third party. It's not inclusive. China and Afghanistan, which have 14% of the catchment area or drainage area, were left out, raising questions about equality of the riparians that Paul mentioned in his including remarks. And then the last point is about the unique and intricate dispute settlement process and mechanisms which I went through and which is really what we have now and what my colleague Kishore Oprati will talk about. And I end up here and thank you for your attention. And I hope I stayed within my time limits, Paul.
Thank you, Salman. You did a great job of staying in the time limits and a great job for the rest of us of really setting up the circumstances that led to the negotiation and the World Bank's involvement in the 1960 treaty, which is really important. There's some unique structural functions to it, to the way the regime with the Indus Waters treaties is set up, and the way, like you're saying, the way the allocation occurred, less percentage based, more based on dividing up the different tributaries and rivers in the Indus Basin, which is just a kind of unique approach. As we move on to the next presentations, it's gonna move somewhat temporally. We're gonna follow the temporal continuum. Kishore Upreti is going to go next. And as I understand it, the focus of Kishore's remarks is going to be really picking up where Salman left off and discussing how the Indus Waters Treaty regime has operated until sort of the recent impasse that has arisen, and some of how the dispute resolution processes and settlement court of arbitration has worked in practice as opposed to in theory as the way it was set up. And when we finish with Kishore's presentation, I think we'll then turn to Mara to talk about the current upheaval or destabilization that's occurring. So I'll turn it over to Kishore. Thank you.
Thank you, Paul, and greetings, everybody. Dr. Salman's conclusion helps me segue into my objective, which is to share examples of specific disputes in the context of the Indus Treaty. And understanding these disputes, which have mainly revolved around the issue of dam construction, water storage, and diversion, in my view, helps decipher the causes of the present situation, partially. So Salman also clarified the three notions, the notion of question, difference, and dispute in the context of the Indus Waters Treaty. And then I would simply add that as a rule of thumb, at the Commission's discretion, any difference can either be dealt with by a neutral expert or be deemed to be a dispute and settled by the Court of Arbitration. This was just as information supplemental to what has been said already, but I will try to share one example from each of the intervention categories. But before proceeding, here are some maps to give you an idea of the system, the existing canals, the existing dams, and again, some dams from a slightly different angle. But now let me talk about a question. The first major question arose in 1985 when Pakistan learned that India was developing the Wular Barrage project on the Jhelum River, some 25 kilometers north of Srinagar. Pakistan claimed that the project would adversely affect its Triple Canal project, and India rejected that claim. Pakistan referred the question to the Indus Commission, which was unable to resolve it. Pakistan then moved to take the case to arbitration. But India suspended construction work. The idea of arbitration was then dropped. But in 1989, again, Pakistan hinted that it would allow the construction of the barrage subject to its inspection. India rejected. Again in 1991, both countries almost reached an agreement, but in the end, Pakistan added one condition, that India should not implement the Kishan Ganga project, which would affect the Neelam Jhelum project Pakistan was planning. Again, India rejected. The Vular barrage question did not go any further. Then came this issue of difference. I will talk about the difference now, which involves Baglihar hydropower project. This project included the construction of by India of a dam on the Chenab River, some 60 miles upstream from the Pakistani border. Pakistan invoked the dispute resolution mechanism on grounds that the dam's water storing capacity was at the level prohibited by the treaty, that the design violated a number of treaty provisions, and that the dam would allow India to obstruct and control the Chenab flow. More specifically, more legally, Pakistan claimed that Baglihar project did not conform to 4 of the criteria in the treaty applicable to the generation of hydroelectric projects on western rivers. And Salman earlier mentioned about it. Let me clarify. For the first criterion, works should not themselves be capable of raising artificially the water level in the operating pool above the full pondage level specified in the design. Pakistan claimed that the project violated this criterion. For the second criterion, the maximum pondage in the operating pool cannot exceed twice the pondage required for firm power. Pakistan claimed that it exceeded twice that level. For the third criterion, if the condition at the plant site make a gated spillway necessary, the bottom level of the gates in normal closed position should be located at the highest level. Pakistan claimed that the dam design did not comply with this requirement. And for the last criterion, the turbine intakes should be located at the highest level, consistent with satisfactory standards of construction and operation of a run-of-river plant. Pakistan claimed that the intakes were not located at the highest level as required. India's general rebuttal was that Baglihar project generation would be through a run-of-river plant, not storage, and therefore it fully conformed to the treaty. After the Indus Commission, Permanent Indus Commission, failed to resolve the matter, Pakistan in 2005 requested the World Bank to appoint a neutral expert to resolve the difference. A neutral expert was appointed after a lengthy process, who, after reviewing all the documentation and position of the parties, delivered a decision in December 2007. At the outset, the neutral expert flagged the approach of his work. First, that the rights and obligations of the parties under the treaty were read in the light of new technical norms and standards and interpreted to permit the fulfillment of its purpose in a spirit of goodwill, considering the best and latest practices in the field of hydroelectric plant construction and operation. Second, that the interpretation was guided by the principles of integration and effectiveness to ensure that each of the objects is given the fullest weight when interpreting the relevant rights and obligations. And third, that the focus was on attaining the most complete and satisfactory utilization of the Indus waters and on delimiting the rights and obligations of each party vis-a-vis the other. The expert addressed the contested issues under 6 headings, and I will summarize. On maximum water that can reach the dam, the expert recommended 16,500 cubic per second as opposed to 14,900 cubic that Pakistan had suggested. On the choice between gated versus ungated spillway, the expert held that the site warranted a gated spillway. On the level of spillway gates, the expert held that the gated spillway on the left wing planned by India was at the highest level, consistent with sound economical stage as a design. On artificial raising of the water level, the expert concluded that the dam crest elevation proposed by India was exaggerated and should be lower. On maximum pondage, the expert held that the values stipulated by both parties did not conform to the treaty criteria and thus needed to be lower. And on power intake, the expert determined that the intake level should be raised by 3 meters and recommended 821 meter above sea level. Baglihar project then proceeded. Let me now talk about a dispute that erupted in the context of a hydropower project on Kishanganga River, itself a tributary of the Jhelum. This project involves a diversion of Jhelum water to Bonar Madhumati Nala via a tunnel. Later, the water rejoins Jhelum via Vular Lake. These information are important. In May 2010, Pakistan instituted an arbitral proceeding at the Court of Arbitration with two main questions essentially related to water flow. The first question pertained to whether the proposed diversion of the Kishanganga into another tributary breached India's treaty obligations. In particular, the obligation to let all the water of the western rivers flow unhindered and to maintain natural channel. This is Article 3 and Article 4. The second question pertained to whether India can bring the reservoir of a run-of-river plant below dead storage level under any circumstance. The Court of Arbitration gave its final award on 20 December 2013. And pursuant to the award, while India, while operating the project, had to release a minimum flow of 9 cubic into the Kishanganga below the project at all times, at which the daily average flow in the river immediately upstream of the project meets or exceeds 9 cubic. But at any time, the daily average flow in the Kishanganga immediately upstream of the power was less than 9 cubic. India had to release 100% of the daily average flow. As a relief, the Court of Arbitration also allowed the parties to seek reconsiderations of the specific minimum flow through treaty mechanism 7 years after the diversion of Kishanganga water by the project. So 7 years after they could reconsider. Reactions about the award were mixed in both countries, along with reservation that few technical matters still remained unresolved. Let me now talk about an interesting twist that surfaced during this past decade. Two distinct processes have been requested parallelly by Pakistan and India for adjudicating same technical issues. The situation is unique, with an underlying risk of inconsistent or even contradictory outcomes. The situation is related to the Kishanganga project, which we discussed already, and the Ratle run-of-river project that India decided to build on a tributary of the Chenab River. The treaty conformity of the designs of these two projects was contested. Regarding Kishanganga design, more specifically, Pakistan challenged India over the pondage at 7.5 million cubic, which it claimed was excessive and should not exceed 1 million cubic. Pakistan also wanted India to raise the intakes by up to 4 meters and spillways by up to 9 meters in height. Regarding the Ratle design, Pakistan challenged India over the proposed lower spillway for sediment management, which it alleged would lead to flooding and therefore wanted higher spillways. Pakistan claimed that the Ratle, under its existing design, would reduce Chenab's water flow, particularly at Head Marala, by almost 40%, which will be detrimental to irrigation in central Punjab. Pakistan asked the pondage to be of 8 million cubic only. India had proposed 24 million cubic. Pakistan asked freeboard to be maintained at 1 meter only. India had proposed 2 meters. Furthermore, Pakistan asked the intake to be raised by up to 8.8 meters and spillway by up to 20 meters. On 19th of August of 2016, Pakistan invoked the treaty's arbitral process through a request for arbitration and parallelly asking the World Bank to initiate the process of appointing the chair of the Court of Arbitration. In the request, Pakistan identified 7 disputed points pertaining to the 2 projects. They broadly concerned the design, permissibility of pondage levels, submerged power intakes, low-level sediment outlets, spillway designs, and permissible freeboard. Pakistan also asked for injunction to India's projects and demanded that the principles applied to run-of-river plants established by the Court of Arbitration already be applied. Interestingly, for the same unresolved technical matters, on 4 October 2016, India requested the World Bank to appoint a neutral expert. 2 parallel processes to adjudicate the same technical difference had thus been requested. After much back and forth about the pros and cons of options, on 12 December 2016, the World Bank decided to halt the 2 parallel processes, stating that they were advancing at the same time, creating a risk of contradictory outcomes, and that could potentially even endanger the treaty. This process was resumed only on 31 March 2022, that is almost 5 years after. In January 2023, a 7-member Court of Arbitration was constituted. India raised 6 major issues and refused to participate. That led to a default appointment procedure. India was against the dual process and viewed the Court of Arbitration as outright illegitimate from the very, very beginning. India opted for a neutral expert route. Pakistan refused to participate in the appointment process, which led to a default appointment procedure. On 13 October 2022, an expert was appointed. On July 6, 2023, the court issued an award upholding its competence and also addressing India's 6 objections. The court in that award stated that India could not preemptively appropriate for itself the power of interpreting the treaty. That a dispute did arise within the meaning of Article 9 to B, and India's insistence on submitting difference before a neutral expert was counterproductive, specifically considering that interim and declaratory relief was claimed by Pakistan, which remained outside the expert's competence. Again, that the requirement for invoking arbitration under Article 9 had been met, given that the parties' meeting in 2016 was unproductive. That contrary to India's arguments, the Court of Arbitration was properly constituted. That India's subsequent appointment of the neutral expert would have no impact, as Article 9(6), which gives priority to a neutral expert when dealing with difference, would not have any effect in preventing the earlier in time application of Article 9. And that the court would have been under a duty to determine that it was not competent only if the neutral expert had been appointed prior to the Court of Arbitration for the same issues. It is clear India's non-participation did not affect the court's competence ruling. But interestingly, the neutral expert also was not deterred. On 7 January 2025, the expert issued a decision reaffirming that India's points of difference on the disputed projects were within the expert's competence. In the decision, the expert stated, and I paraphrase here, that while Pakistan might wish to pursue its claim in a way that set the rules of the game for all of India's hydroelectric plants, that would not deprive the neutral expert of competence over difference that fall within the scope of Part 1 of Annexure F. that while the neutral expert's competence was limited to technical matters, those matters would still need to be interpreted by a neutral expert. That there would certainly exist a difference in the legal consequence of a decision by the neutral expert and the Court of Arbitration. That there was no provision in the treaty precluding parallel proceedings, even if it involved addressing certain overlapping matters. And finally, that the neutral expert had a mandate to resolve the difference submitted by India with reasonable expedition. While both the court and the neutral expert upheld overlapping competence, uniquely instantiating parallel proceeding under one single treaty, the court on 27th June 2025, that is some 2 weeks ago, rendered another supplemental award on competence, which is even more interesting as it touches upon India's recent pronouncements about suspending the treaty or putting the treaty in abeyance. And it's important. What the court said is important. In the award, the court stated that its competence cannot be affected by the unilateral decision taken after the initiation of arbitral proceedings. It also asserted its continuing responsibility to advance proceedings in a timely, efficient, and fair manner. And most importantly, it mentioned that the findings also apply to the neutral expert. Not surprisingly, the award has been hailed by Pakistan and rejected by India. Stress in this regard thus persists. And we need to wait for the final award of the Court of Arbitration to assess all ramifications of this case, which creates an interesting precedent. And I think I will stop here. I hope I'm within my limits, and I thank you very much for your patience.
Thank you very much, Kishore, for a fantastic and concise and on-time overview of some of the major disputes that have arisen under the treaty. Sort of two takeaways before we turn things over to Mara for the final presentation. One, as we look from the 1985 Wooler Barrage, 2005, the Bagliar dispute, 2013, Kishan-Ganja, and the more recent dispute involving the Rutley project, at least for the first three, we see the dispute resolution procedures, whether it's the neutral expert or reliance to the Court of Arbitration. Obviously, there's contesting positions, but the dispute resolution procedures worked well. The parties participated in them. They generally accepted the outcomes of them. And I think that experience is one of the reasons why the Indus Waters Treaty became known as I'm not going to say a complete model, but a highly functional, durable, resilient regime. As we move into the current situation, which Mara will cover, I think the end of your presentation, Kishore, was really key, which is we started to see with the Rutley project, I would describe it as it started to wobble, and maybe it's still wobbling, in that, maybe it was related to, on one level, the issue of that there were dual processes going on between the neutral experts and the Court of Arbitration, and some dissatisfaction kind of structurally with that. But underneath those kind of structural dual process concerns were actual concerns about the allocation and the operation of the terms of the treaty, and getting back to some of my initial points about whether the way the treaty was being operated and interpreted was still really fair and equitable. India started raising those more fundamental concerns, questioning the competency of the dispute resolution process in a way that they hadn't previously. So I'll turn it over to you, Mara, to pick it up. But I think what Kishore covered, particularly with the Rutley project, and I'll call it the wobble, is important for understanding where we are now. So I'll turn it over to Mara.
Yeah, thank you. So my task today it is to go into the topic of the suspension by the government of India. I think that many of you have already seen this document that was available in the social media. And if you read this decision of suspension by India, you can read in the fifth paragraph. No, it is mentioned the government of India has hereby decided that the Indus Waters Treaty of 1960 will be held in abeyance with immediate effect. So it is interesting to see that it is not using not the term suspension, but of abeyance, but of, for the uh, for what also said the arbitration tribunal, we can use in a changeable way these two terms of abeyance and suspension. So in April 25, India formally notified Pakistan of its decision to suspend the Indus Waters Treaty, and in its official communication, it appears that it used two justifications for this decision. So the two main justifications were a fundamental change in the circumstances since the treaty entered into force, and the second justification that was indicated was a material breach of treaty obligations by Pakistan. So specifically, India pointed out to a sustained, I quote, sustained cross-border terrorism targeting the Indian Union territory of Jammu and Kashmir, end of quotation, asserting so that the ongoing hostilities have generated, and I cite, security uncertainties and also impaired the India ability to fully utilize the water entitlements of India under the treaty. So now the questions are, do the justification cited by India meet the criteria of a fundamental change of circumstances as understood in the Vienna Convention on the law of the treaties that reflect the customary international law? And the second question, it is, can persistent cross-border terrorism and associated security concern be deemed as a material breach of treaty commitments, justifying so a unilateral suspension? So in my presentation, I will evaluate these two India justifications against the legal framework for treaty suspension recognized in the customary international law. I would like to start by reminding Article 26 of the Vienna Convention, the law of the treaties, that includes the principles of pacta sunt servanda, meaning that a treaty must be performed in good faith by all parties. So the primary legal justification that India is using for justifying the suspension is related to the fundamental change of circumstances that includes the so-called doctrine of rebus sic stantibus, which allows for the termination of the treaty if some criteria are met. So what are the criteria that must be met? This is not the question. So the first criteria, it is the unforeseen character of the change in the circumstances, and also the fundamental change. And this unforeseen and fundamental change of circumstances, so both features, unforeseen and fundamental change, must have radically transformed the obligations imposed by the treaty. So here we see basically three criteria: the unforeseen character, the fundamental change, and the third one, it is the radical transformation of treaty commitments. So while this clause is frequently invoked by states, this ground is rarely accepted in international practice. And why it is rarely accepted? Because of the importance to maintain the stability and the continuity of treaty relations. And this is clearly affirmed in a well-known case of the International Court of Justice, the Gapchikovo-Najimaros case, that affirmed, no, I quote, the negative and conditional wording of Article 62, so Article 62 of the Vienna Convention on the Law of the Treaties, it is on the fundamental change of circumstances, is for the court a clear indication of the importance to ensure stability of treaty relation. And this requires, the court says, that the plea of fundamental change of circumstances must be applied only, the court says, in exceptional cases. So no, we see here the high threshold to meet the requirement of fundamental change of circumstances. So for such a claim to succeed, the alleged change must have been unforeseen, so by the parties at the time of the conclusion of the treaty. Two, it must constitute an essential basis of the consent to be bound by the treaty. And the third criteria is to have altered the nature of the obligation in an essential way. So in the Gapchikovo-Najimaros case, to remind again this judgment, the ICJ re-emphasized that this ground requires that the change of circumstances radically transform the extent of the obligations in something that is essentially different from what it was established at the beginning in the treaty, and again the circumstances must be unforeseen. And it's interesting that also in this case, in the judgment Gapchikovo-Najimaros, the court indicates that new developments in the state of environmental knowledge, arguably including also climate change issue, cannot be considered as unforeseen. These precedents that we can see in the Gapchikovo-Najimaros case indicates that no party may unilaterally abrogate its obligation on the vague basis of changed political, social, or environmental condition. So in light of what I said previously, the claims of India in its official statement of April 2025 regarding the altered population demographics and the need to accelerate the development of clean energy do not constitute a fundamental change of circumstances. So let's go to the second justification that was claimed by India regarding the material breach of treaty obligation. So this is contained in Article 60 of the Vienna Convention on the Law of the Treaty. So under Article 60 of the Vienna Convention on the Law of the Treaty, a party to a bilateral treaty may suspend its obligation if the other party commit a material breach defined as a violation of a provision essential to the object and the purpose of the treaty. So the material breach must concern the object and the purpose of the treaty in question and not another situation. So this legal ground is also setting a high threshold that is also in this case intended to balance the stability of treaty relations with the case of flexibility if there are serious violations of the treaty in question. So the breach must pertain directly to the core provision of the treaty itself and not to external political or security issues. So in this case, India has not put forward evidence to justify that Pakistan has breached any substantive provision of the Indus Waters Treaty in itself. And allegations of terrorism, of course, they are grave, but they fall outside the scope of the treaty and therefore cannot be presented as a material breach of the core provision of the Indus Waters Treaty, that is a water sharing agreement. Moreover, also no, the Indus Water Treaty, as just presented by Kishore, includes a detailed dispute resolution framework that India was obligated to pursue before taking the unilateral action to suspend the Indus Waters Treaty. So India showed to bypass the process of the dispute resolution, weakening the legal legality, the legal validity of its claim under Article 60 of the Vienna Convention on the law of the treaty. The India's assertion that Pakistan alleged support for terrorism justify the suspension of the Indus Water Treaty is legally inconvincing. Why? First, because a terrorist incident, even if state attributed, concern political and security matters, which do not alter the physical or institutional operation of the water sharing agreement that is the Indus Water Treaty. Second, according to Article 11 of the Indus Water Treaty, it says that the existence of any fact which, if established, might constitute a breach of this treaty shall first be established by the Permanent Indus Commission. So in the case of any fact that would constitute a breach of the obligation of the treaty, there is an obligation to go firstly through the Permanent Indus Commission. And third, the treaty has remained in force during armed conflict and decades of hostile relationship between the two countries. So this suggests also that the Indus Waters Treaty continues to operate in an independent way of the fluctuating relations between the two countries. So, no, my argument it is that the India position does not satisfy the stringent requirements neither of Article 60 on the material breach of the treaty, nor Article 62 of the Vienna Convention on the law of the treaty on the fundamental changes of circumstances. And with this, I conclude my presentation. Many thanks.
Thank you very much. A lot to chew on there, Mara. Hopefully we'll be able to return to some of that in our discussion now. So we have, I show, about 14 minutes. We did a pretty good job of staying on track, and we'll try to use that time. I'm going to turn initially to some questions that were put in the Q&A box, and I'll try to direct them to our different panelists a little bit. There were two interesting questions put by Dr. Bilal Iftikhar. One seemed to be directed specifically to Salman, and the other to the panel more at large. And I think I'll put those out there. First, the one to Salman, and then we'll take the second one. The first question that was put in the question box was, Dr. Salman, if you were to revisit the treaty today, what specific provisions or mechanisms would you have liked to see included? So I think, the preface to this question was that the treaty itself, is widely recognized, it's characterized here as a remarkable framework, but that we're now seeing some problems come up that are posing a real challenge to the regime. So I'm going to ask you to go in the historical time machine, Salman, and say if there are certain provisions that could have been addressed, either they weren't addressed or addressed differently in the original treaty, that pertain to the current dispute. Do you see changes to the structure, the language in the treaty that might help us with this situation?
Thank you, Paul, and thanks for the uh, question. I think it's a really very, very difficult and very large question. What could we do? I mean, this is a treaty that was negotiated in 9 years with very fine experts from both countries, with the mediation of engineers from the World Bank, and with assistance from sometimes people outside the World Bank. So I think looking back at the situation in 1950, 1947, 48, 49, when the issues came up and they were addressed, is completely different from now. I mean, some articles were written now about the aspects that Kishore and Mara mentioned about the climate change, about the environmental degradation, about the issues of dams and how they should be planned and built. I think if I were to revisit, I would really try to simplify a little bit the provisions on dispute settlement, because the whole issue now that the treaty is turning around is dispute settlement. Cases in Baglihar, I handled Baglihar when I was at the bank. It was really a very difficult situation for me, but we handled it and we handled it very successfully. So I would really try to simplify the dispute settlement process. How would I do that? I would look at the three cases that now have now been either decided or still pending, and look at the difficult issues that came up, the issues of putting a court of arbitration and a neutral expert at the same time, with the risk of getting conflicting or inconsistent or maybe conflicting. I think those are this is a very large experience, which we had since 2005 for the last 20 years, and we have a lot of experience, and we can look into the issues of simplifying the dispute settlement process and mechanism.
Thank you very much. Second question from Dr. Bilal Iftikhar, I think was more to the panel at large, so I would propose that maybe Mara Kishore take a shot at this one. But the question that was put out there, and I'm trying to find, here it is. Quote, how can Pakistan seek enforcement or international support in a case where one party effectively rejects a multilateral legal process? End quote. And I think this question really goes to the perceptions of the legitimacy or competency of the dispute resolution process, and whether India is required to abide by it. We're left with a situation right now where, regardless of, we could argue the legal merits of the answer to that question, but India is now at least taking the position of calling into question the competency of the process, the legitimacy of the process, and its obligation to participate in it, and where does that leave us? So I'll put those questions initially to either Mara and or Kishore to take a shot at responding.
I think you should decide who should
I
start.
should decide.
Kishore
first.
I think Mara should respond first, because she's already implicitly talked about it. So I would like to request Mara to provide your comment.
Okay, but we welcome yours as well.
Sure.
Yeah, I think that unfortunately this is something that we see in international relations in many situations, that multilateralism is put in question. So I'm an optimist. So I would say that maybe now no India is taking this position, but this can change over time. And also no we must not forget that there are not only treaties, no, and conventions, but there is also customary international law that applies to these countries. So, no, India, no, is also bound to comply with customary international law and also principles of customary international water law, so including equitable and reasonable utilization, for example. Thank you.
Yes, I think the quick answer, the very short answer to this particular question is there is no police force to implement. These are bilateral issues, and the treaties are negotiated by more than one party, and especially when there are two parties and one party is not fulfilling, there is violation. But what else can you do? This is a practical question. I would like to simply add one more thing here. I mean, is that there are practical. There are some issue of practicality in taking an action in the context of a treaty, and there are legal actions. Legally, I think this goes be. I already said, Mara has already said there is, and I say there is no police force to implement. The countries have to respect what they have negotiated and agreed. But there are also, I mean, what can be done right now? Basically, I mean, there are the water continues to flow, and the damage will definitely be there, but not to the extent of stopping the entire flow of water. And I would also like to bring here another small element, which is that when the Indus Treaty was being negotiated, there was one point where the negotiators had to exclude the Kashmir issue, and Salman is aware of that. And I know that they had said that there will not be any discussion on and Kashmir issue. At that time, it was boiling, and that was excluded, and treaty negotiations were possible. And that's why the treaty basically is a technical treaty. Basically, it has been referred to as an engineer's treaty and so forth. But I think the quick answer is that if the two parties do not respect what has been signed, there is very little that others can do. Legally, there is some kind of, there is no provision in the treaty, for example, of terminating. They can change the treaty after they have signed another treaty, right? So these are important points. But giving a one-shot answer to this kind of complex question will be difficult. I rest here.
Thank you, Kishore. We have maybe 5 minutes or so left. I'm going to exercise moderator's prerogative and put a final question discussion topic out there. So, Mara, in your presentation, you sort of examined the issue of material breach within the treaty and whether it affected sort of core provisions. And I think that touches on some of the national security issues related to the recent terrorism attacks. And whether that's really part of the core provisions of the treaty. Obviously, the core concern for India, but as to whether that provides a justification for material breach, as that term is used in international law, international water law, erase that. But I wanted to return to the other point that you made, which was this argument related to changed circumstances. And, putting aside the terrorism and the national security issues and the Kashmiri situation, one of the other contentions that India made and has made is that there are changed, I'm going to put this in quotes, demographics that have occurred since the 1960 treaty was negotiated. To the best of my knowledge, I haven't seen a great deal of elaboration on what those demographics are. Other than that they seem to be related to the fact that, to break it down as I understand it, India's position is that due to population shifts and economic shifts, they need more water now than they thought they needed back then. Maybe you understand it differently, but I would be interested to hear from the panel sort of two parts. One, what is your understanding of what India means when they say there are changed demographics that might provide justification for this changed circumstances argument? What exactly are they referring to? And I guess a related point is um, to be able to invoke that, as Mara pointed out, if those changes were foreseeable, they have to be unforeseen,
Paul?
right? So I'll leave it there, but just the issue of changed circumstances, changed demographics, whether it was foreseeable, um, make that our final topic. And I'll put it to any of the panels that want to take a shot at it. Mara, maybe since you brought it up, maybe I'll let you go first since you were the one that raised it in your remarks.
Yeah, for me, what it is astonishing for me, it is that these changes, no, in population or the need of clean energy must go through cooperation. No, but unfortunately, India is doing this through a unilateral suspension. So this is a challenge that are, I think, common in many countries, but the key is that this must go through cooperation and not unilateralism and not unilateral action. And there, no, we have a joint mechanism like no, the Permanent Indus Commission that is there exactly for tackling this issue like changes in demographics or addressing clean energy installations. So for me, the key word here it is really cooperation, not unilateralism, and using the joint mechanism that are in place under the treaty. Thank you.
I would also like to add, absolutely agree with whatever Mara has said. This is a case of cooperation, and the idea of the Permanent Indus Commission is there to be able to come to solve these kinds of crises. But we cannot go, I think, beyond whatever is provided by the treaty. And in a sense, whatever Salman has said, that some dispute resolution mechanism improvements are needed, may be a valid point, but this again has to be done in discussion bilaterally between the parties. Thank you.
Salman, maybe we'll
Yeah.
conclude with your thoughts.
Yes. I have read a couple of articles about the changing demographics, which India is basically saying, look, how many Indians were there in 1960 when the treaty was signed, and how many are there now? And so those are changing circumstances, and we need more water, we need more energy, we need more of this and that. And obviously, I mean, this is true, but the same thing applies to Pakistan, and the same thing applies to any riparians that share shared water course. And I agree fully with what Mara and Kishore said, that this has to be done. It has to be done through cooperation. It has to be done through joint projects, not through unilateral action or through threats. And I think, and this is basically when we talk about cooperation, we're talking about international water law. International water law is a law of cooperation. This is what we call it. So yes, there are certain changing circumstances, but when changing circumstances applies to both parties, to the decisions that have to be made to face those changing circumstances have to be done in a cooperative spirit by the two parties together and not unilaterally by one of them.
So with that, we are almost out of time, so I'll just make some very short closing remarks and we'll wrap things up. I guess by way of closing remarks, this is an unfolding story. So I think we've had a really great discussion today to sort of map out how we arrived here and to frame the issues, and we will see how it plays out in terms of recent developments. In recent days, we have had rulings by the Court of Arbitration on the competency issue, and I'll simply note that I think where the Court of Arbitration is now seems consistent with where our panelists are, in that the issue is whether they have competency to hear the dispute in light of India's actions to put the treaty into abeyance. And essentially, at least the initial rulings by the Court of Arbitration were there's no such thing as putting anything in abeyance under the treaty. you're still subject to the treaty. I don't know what the court essentially rejected India's position about what abeyance means and its effect on the legitimacy of the proceedings, which seems fairly consistent with what I'm hearing from all three of our panelists today. As to how that will play out in the real world of politics and how this gets resolved, we will just have to see. So with that, I would like to say thank you to the Geneva Water Hub for joining to co-sponsor today's event. Thank you to Salman. Thank you to Kishore and Mara for your great presentations. And thanks to all of you for joining us today. Take care.
Thank you.
Bye-bye.
Bye.
Thank you.